This lecture will cover the professional conduct of land surveyors. So what is professional conduct? This term can have many implications and many different aspects. So there's really like two flavors here. One is the regulatory or legal side of professional conduct, and then there is what we consider the conduct of a true professional. And a true professional could be any profession, lawyers, doctors, clergy, architects, etc. So good professional conduct, regardless of which flavor, is generally overlooked when it's good, but it is still expected to be good. And it's often mandated by rules and laws in each state according to what each state feels like is most applicable and what they want to stress. But being a true professional reaches beyond compliance with regulations, and true professionals do a lot of things that are not mandated, such as mentoring young surveyors, giving back to the community, volunteering, supporting charities, sponsoring charitable events, and also giving reduced fees or pro bono, which means no charge, services to worthy causes. Perhaps there's someone, I've seen this, done this many times, someone who was minding their own business and their neighbor has had a survey done that is probably wrong and has caused this innocent person that was minding their own business a lot of stress and grief. And they don't really have the money to pay for a survey. Maybe they're elderly and on limited income. And the surveyor there needs to be a true professional and step up and help this person in the community, even if they can't afford to pay. And attorneys recognize this and specify a certain amount of pro bono work to be done each year. And you can even look into biblical times at tithing and how that certain parts of the crop were left for the poor. So being a professional doesn't just mean you got a professional salary. It means that you're held to a little bit higher standard in the community. And that's what we as surveyors need to strive to do, is not just be the guy who's smart or gal who's smart and who can make the closing happen and collect a nice fee, but provides a real service for society. Going back even to Thomas Jefferson and George Washington and Lewis and Clark, those people weren't doing what they did for money. Well, they did it for subsistence and for income, but they did a lot more just for the betterment of the community, not just their own pocketbooks. So we're going to explore mainly the regulatory or legal side of professional conduct in this module. And there are several aspects that are pretty uniform from one state to the other, even from one profession to the other. You'll find a lot of these same things in engineering, in architecture, and even interior design, or even sometimes in the practice of law or medicine. Podiatrists will not often go and take out somebody's tonsils because that's practicing outside of the field of expertise, even though they may be licensed to do so. So we're going to just focus on the regulatory or legal side. So here's the most common one, in my opinion and experience, is that surveyors are to practice within one's field of expertise. So the general premise is that surveyors should not accept assignments for which they don't have adequate training and experience. So what is adequate training and experience? Well, this would be competencies. And in Georgia, under the new apprenticeship requirement, applicants are to build competencies and submit those, because it's not expected that we become experts in every single thing that land surveyors can do. We've looked at the various services that surveyors can offer besides a survey plat, and it's not really possible for any human to become expert and on the top of their game on every single one of those aspects. So we, as humans, as professionals, regardless of the field, tend to focus on areas where we're comfortable or where we're most intrigued or most engaged, or maybe it's what we find to be the most profitable. And these areas where we become very competent are our field of competence, our field of expertise, or our scope of expertise. We can certainly have more than one, but it's not likely that we'll be competent in all, like I was just saying. So this doesn't mean that we can't expand our field of expertise. We certainly can. Say that your field of expertise today is doing topographic and engineering type surveys where you're picking up topography, trees, vegetation, utilities, storm drainage, and you're really good and competent at that. Nothing that says that you can't also later become competent in establishing tidal boundaries down along the Atlantic Ocean. It's just a whole lot different approach from that. So you would have to learn that additional expertise. And so that fine line there as to what is my expertise today and how do I grow it without crossing the line becomes something kind of tricky sometimes. So some surveyors I have seen with my own experience, especially when I was on the state board, perhaps they were very competent doing farm surveys in East Georgia. You know, just solid of the earth, bread and butter, boundary surveys, 100, 200, 800 acre farms. You got fence lines, turn rows, axles. They knew all the local surveyors. They knew what they were doing. Super duper farm surveyors over in East Georgia. And then one day somebody called and said, hey, I need you to go survey this commercial property in Atlanta or Augusta or Savannah. And it's got party walls and it's got 13 title exceptions and it's really messy. And so they say, no, I think I'll just stick around here and survey farms. And they say, well, you know, we'd love for you to do it. We got a quote for $12,000 to do it, but they're 2 months out. We need it done. We thought maybe you could do it for us. And so the surveyor goes, wow, $12,000? I'll do it. And their approach is they'll learn on the fly. And they made some mistakes, and it cost the title insurance company a lot of money to fix what they messed up, and then they went after the surveyor. And he was without much defense because his defense was, well, this was my first time doing something like this. Or, well, I had never surveyed anything like this before. I didn't realize that's what it meant. Those are not adequate defenses. That is basically admission of guilt, and in the civil world, admission of liability for which you're going to pay. So if you're a farm surveyor in East Georgia and you want to expand your business into doing high dollar commercial ALTA surveys in the more metropolitan areas, that's fine. You might just want to partner with another surveyor. You know, someone that you know, hopefully from school or from your professional society or whatever. You know, it pays to be connected with other surveyors and get them to help you. Even if you don't make money on the first one or two, ease into it and get their help. You might even just, I have done this myself as we embraced new technologies and things. I paid people to help us do certain aspects and do certain types of projects who had the expertise, licensed surveyors. Paid them so much that I didn't make any money on the work the first 1, 2, or 3 times, but we gained the competency, the confidence, not just the competence, but the confidence to know we're doing this right, because a professional should have the confidence that what they're putting out is correct and they're able to answer for it. The surveyor I referred to, he did not have any confidence in his work. He was just throwing it out there and hoping it would fly, and it didn't. So do whatever it takes to get the confidence that you're competent to turn out the work, and you'll be okay. One real common pitfall is equipment salesmen are really bad to say, hey, buy this new machine for me and you can go do those $12,000 Alta surveys on these shopping centers in Atlanta. I'll show you how to do it. That's not the same thing as a true professional surveyor getting involved and helping you, or you easing into it. You don't necessarily have to partner with another surveyor. You go into another field of expertise, you can take and learn and study examples yourself to ease into something like that. You might start in that hypothetical that I gave. You might start by going from East Georgia farm surveys to maybe surveying a convenience store Alta that's not too complicated. Seeing how the review process goes, get some feedback. Circulate your plat to some other surveyors and say, hey, can you give me some feedback on this? And gain that, that confidence that what you're doing is correct, and work into it. Just don't jump out into a field that's outside your expertise and expect to not get burned. Another, big topic of professional conduct is adequate supervision of your unlicensed subordinates. Most states have something that says something along the lines of, the surveyor shall not affix his or her seal to any plat, plan, or document unless it is prepared by the registrant or by individuals under the direct supervisory control of the registrant on a daily basis. That's a quote out of Georgia's rule. So traditionally this meant everybody was under the same roof in the same building, unless a field crew was working on the road, for example, but otherwise you were having daily contact, physical contact in person every day. Now, between technology, telecommuting, and then COVID, most states, including Georgia, have addressed remote supervision as being allowable, but it still has to be daily supervision by the registrant and to make sure that things are being done right. Now, why is this important? All right, so direct supervision kind of falls into two categories. The first one is the one you don't think about very much, although you might, and that is supervision for the purpose of becoming licensed. So if you're hoping to be gaining experience right now that applies towards licensure as a land surveyor, you need to be under the direct supervision of a registrant who is instructing you and mentoring you into how to do things. So this first category is experience applicable to licensure requirements. So that needs to be pretty in-depth, more so than just to be lawful for the turning out of work product, which is the second and larger category. So we're looking out for the public. That's what the state board rules do. That's what we as professionals are supposed to do. So if you're not adequately supervising your subordinates, there's not too many good things that actually come from that. The one slightly good thing is you're not spending your time and theirs supervising, so they're getting more work done, so it's more profitable and it puts more money in the bank. That's the temptation, and that's usually the cause for under supervision. Obviously that's not wholesome and that's not really a good thing. That's just that's the lure. Is I know he's doing it wrong, but dang, he's doing 5 of them a day. He's making us a lot of money. Or, yeah, he's doing it good enough. I don't have time to sit down and teach him how to do it right. And he probably would listen to me anyway. So we're just going to carry on. That's not a good approach either. So failing to adequately supervise means that the staff might be doing something really wrong and nobody knows it until it hits the fan. Under-supervised people may be taking shortcuts because they're not being supervised. Nobody's making them do their homework. Just as an example. Obviously not homework, but they're not being held accountable. So they're cutting corners and they're not doing the best job that they can because they feel like nobody cares. Damages incurred by clients where survey errors and mistakes have been made, and they can be traced back to under-supervised subordinates. In my years on the state board, and in some of the cases I've been involved with as an expert witness, surveyors tend to think that they have some kind of excuse, some kind of out, because, well, I let Jeannie do that, and she's been doing this a long time. I thought Jeannie knew what she was doing. I can't do it all. We're allowed to have employees. This, it's true that we overlapped the neighbor and it caused this problem, but it's really Jeannie's fault. That defense does not fly. I'm very surprised that people still try to use the defense of my employees did it. My employee improperly affixed my seal to that plat. I was not ready for that plat to go out. My employee put my seal on it and sent it to the closing attorney while I was on vacation. None of these excuses hold water. The land surveyor is still responsible for the actions of their subordinates. And really, all these defenses that they think they're putting up are really just admissions of guilt and digging a deeper hole. So this is not a lesson or a hint to don't have any employees, don't have any subordinates. No, it just means make sure that you are able to adequately supervise and manage your resources. Don't spread yourself too thin. Bad things can happen. This next topic sort of goes without saying that we have to have truthfulness in statements and testimony. We won't dwell on this too much, but surveyors can make all kinds of statements. We put a note on a plat. Adjacent owner claims fence is property line. Okay, that's a statement. What are we basing that on? Well, presumably the adjacent owner told the field crew that, who noted it and relayed it to the surveyor, who made sure that got put on the plat because that's relevant to the status of the boundary. Statements can also be verbally made on the property or in your office or on the telephone, saying, yes, your building is 24 feet from the property line. Well, that's a statement that was made. As professionals licensed in whatever state we may practice in, the public has a reasonable expectation that they can rely on our statements. So they have to be truthful and accurate and based on facts, calculations, and observations. We can't just say, yeah, Fred probably moved that corner. Or I bet Jim set that corner, after he got home from work one night. That pen ain't nowhere near close. Well, a lot of that speculation, things that can't be supported, you don't need to make those statements. Understand that our statements are limited to those that can be supported by facts, calculations, and observations. Conflicts of interest. This comes up a lot, and this just basically means, we have a duty to look out for the interest of a party. All right, if you're an employee, your first duty is to look out for the interest of your employer. If you're self-employed, your duty is to look out for the interest of your client. If you're a professional, you're inclined to look out for the interest of your employer and your client and the general public. And if you're an employer, also your employees. So sometimes these interests are not the same. For example, might be in the company's best interest, just say you're an employee of a company. It's in the company's best interest that you don't go back out of this job and incur any more expense. You want to stop right now while there's still profit left in the job so that you're viewed favorably. But you have reason to believe that the pen that the crew found is not where it's supposed to be and that they might not have looked where it's supposed to have been. Maybe there's an old iron pin or a rock or something 4 feet away That's probably where the corner ought to be. So you have a conflicting interest there. You have an interest to your professional license and to the state board rules to get the job right. But you also have an interest to make it profitable for the company. So what do? Hopefully you go with what is the correct thing, and that's to go back out there in spite of profit and get the job right. There's this other aspect of conflict of interest of, well, what's good for this side is not what's good for this other side. So say two parties have hired you to survey their property and it's next to each other. And you didn't know it at the time, but wow, they're fussing over a fence. They both think the fence is on their property. Well, one side's going to be disappointed when they find out that the fence is on the neighbor's property. So you have a little conflicting interest there. Or more commonly, you just surveyed party A's property and you feel really good about it. Then party B comes along and says, I don't know who surveyed my neighbor's property, but they got it wrong. I need you to survey my property and get it right. Well, there's a conflict of interest. You can't satisfy party B because you're already firm on where the property line is from where you surveyed for property A. So that's a conflict of interest. You need to say, well, party B, I'm the one who surveyed your neighbor's property. I'm sorry that you're not happy with the outcome, but I can't survey your property because I'm not going to be able to differ from what I've already done. I feel good about it. I'm very sorry. Maybe we can talk about this and you can understand why my survey is correct. Otherwise, it might wind up in court. But as long as you've done your job right, those things are just going to happen and are beyond your control. So a lot of times you just have to kind of zoom out and discuss it, talk about the conflicts with the two parties that have the conflicting interest. And often you just have to abstain or walk away and say, I'm sorry, I just can't do it. Another little flavor of conflict of interest is the multiple compensations for the same services. Now, you wouldn't think this would happen, but it does. A general common canon of rules of professional conduct and professional ethics is that we not receive compensation for the same service from multiple parties. In other words, if you just surveyed lot 5 for somebody and they didn't buy it, and somebody else calls up, their realtor gave them your number and says, hey, I'm buying lot 5 and I need a plat. And it looks like somebody's just surveyed it, so it should be really easy. Do you charge them the same thing that you just charged the other person? So here's where it gets really clouded in my opinion. If it's right then and there, same proximity of time, like say a couple of weeks, maybe longer, but definitely anything inside that time frame. And you've just done the service for one person. You can't just charge the second person the full price because then you're double dipping. You're charging the same service to two different people. That's not ethical. Now, it's worth the same to both parties. You don't really have necessarily a legal requirement to disclose to the new buyer that you just surveyed it 2 weeks ago. But you have an ethical requirement to say, I just did that. Let me reach out to the former client and see, because I see what they want to do. Ideally, if you charged $1,000 to the first client, you say, hey, I know you didn't buy this. Somebody's wanting to come along. How about if they gave you some money towards what you paid? I've still got to go back out there, or maybe I don't, depending on the time frame and the client's expectations. And I've got to change the plat. I got to change the name. I've got new parties that I'm liable to. I can't just change the name for free. The least I know of anybody doing something like that, it's like $125. It should be more like $200 or $300, but that's still not the same as a whole new survey. So you can't just give the new client a $1,000 survey for $300 because you done surveyed it for somebody else. you just have to work through that. You have to really just try to bring both people together and say, hey, and often I've done this. The first client is very appreciative. They'll give you 5-star reviews, high fives, Christmas cards, and say, wow, they got me $500 in my survey feedback. I didn't buy that property. I was out $1,000, but the surveyor was looking out for me and got me $500. Now the next client, they pay the other $500, or that they pay that person $500, then they pay $300 for the name change. They got a $1,000 survey for $800, and you've made money off of both of them, and you move them down the road. Everybody's in full disclosure. Everybody knows what's going on. That's the appropriate way to handle that. Sometimes this runs afoul. A friend of mine had a situation recently where buyer number one hired him to survey this property, and then he couldn't close. And he said, under no circumstances, use this survey for anybody else. And I want to maintain complete control of it. Now, it's a little fuzzy without a contractual agreement that says who owns the intellectual property, because otherwise the land surveyor owns the intellectual property and can do what he wants to with it. But in this case, it was still fresh. The deal had not closed. Buyer number two comes along to the same surveyor and says, hey, I need this property surveyed. And this was like 40 or 50 acres, a pretty complicated survey, several $1,000s worth of surveying, took many weeks to get it done. So this surveyor tried to work it out with both parties. They said no. The first surveyor, or the first client, said no, we don't use it under any circumstances. So they completely redid the survey so that they were compliant with this and were not charging for the same service. It was the same property, but the first client paid for the first traverse and plat. Second client paid for the second traverse and plat. Very rare. Only time I've ever heard of that happening, but it was the only way to stay out of legal hot water, because surveyor or client number one had an attorney who knew about board rules and professional statutes and was making threats to the surveyor about not reusing it. And this was the only way that he could satisfy client number two without breaking the rules or violations. But now let's talk for a second about a little bit different flavor. Let's say that you surveyed lot number 5 for owner number 1 who bought it from the builder. 2 years later, they're selling it, and the new buyer comes along and says, hey, I'd like a survey on lot number 5. All right. In my opinion, you can charge what you want to because you're offering a new service. I mean, you need to go out there and verify the corners, verify the house, make sure they haven't added on to anything. But you're providing a new service to a new client, and that new client didn't pay for your first survey. They don't have any investment in your first survey. If that new survey is worth the same or more as it was to the first client, then I don't see a problem in charging for that. Some may try to really pull this multiple compensation out and say, no, you've already surveyed that lot one time, you can't charge to do it again. I don't believe that's what it's speaking to. I believe it's in that, in that like 2 to 4 week window when everything's fresh. You can't be double dipping and charging the same people and ripping people off. It's unethical and unprofessional. But if time elapses, maybe it's just a few months. 6 months ago, we surveyed a large commercial property in Atlanta, a shopping center, anchor store, fuel islands, the whole 9 yards. They refinanced a month ago and needed a new survey. Now they came back to us. Their main thing was they were wanting a shorter time frame, not a bargain or a discount on the survey fee, but in order to give a new date to satisfy the title insurance and the lender, we had to go verify 18 property corners and like 13 lines along the boundary to make sure that nothing had changed. Whole new title commitment with like 27 exceptions had to be reviewed, renumbered. They had dropped a couple from 6 months ago. They added a couple. One was new, one had been overlooked. It was a new product. I didn't charge the same thing that we did for the original survey where we started from scratch, but I charged about 60% of it. And they were pleased because they got their money's worth. They also knew that we had previously surveyed it, so everybody was on the same page and knew what was going on. The moral of that story is you just have to approach things case by case, try to determine what's the most ethical, read the rules, and try to make sure that you're understanding and complying with the rules that affect what you're up to. Now, let's step out for a minute and let's look at the legal aspect of your work product and how statutes of limitation and repose works. So a statute of limitations can be for a crime. For example, the statute of limitations on car theft might be 10 years, meaning if you stole a car, got away with it for 10 years, and then you get caught 11 years later, if the statute of limitations 10 years in that state, you can't be prosecuted. You got away with it. Now, we're not criminals, but let's say a survey error is out there. The damages that could be incurred by a party because of the survey error. In other words, the fence is over the line, has to be torn down. It's a nice fence, it's 300 feet long, it's going to cost $10,000. There's your damages. Cost of moving the fence plus legal fees and such as that. What if your property line was off by 3 feet and now Walgreens doesn't want to buy the property because they can't fit a store on it, and somebody loses a $3 million sale? Now your damages for that 3-foot survey error are $3 million. So we have to be cognizant of this. Now, statute of limitations generally means that the time frame for recurring damages is that long after the error is discovered. So, in other words, if it was a statute of limitations of 4 years, which is one of two common scenarios, for example, in the state of Alabama, 6 years goes by and nobody realized that you made a survey error in Alabama. And then they do. They find out because they try to sell to Walgreens. 6 years. So are you in the clear because it's more than 4? Actually, under statute of limitations, it's going to run generally from the time the error was discovered. So they have up to 10 years in that example. If it had been found 7 years later, they'd have 11 years. So your time frame for being liable for damages can be a very long time with a statute of limitations. Statute of repose, that time period starts when the act occurs. Georgia's law is commonly referred to as a statute of limitations because that's the more common legal term, but it's really a statute of repose. And that's because the 6-year period for seeking damages due to survey error begins at the date of the survey or the plat. And that's Official Code of Georgia annotated 9-3-30.2. So understand your liabilities and your limitations. Understand the difference between a statute of repose and a statute of limitations. So another aspect of professional conduct is professional liability insurance. This is also and was historically known as errors and omissions insurance. So surveyors will usually have workers' compensation insurance in case employees get hurt on the job, automobile insurance on their work trucks. They'll have insurance on their contents of their office due to fire or theft. General liability insurance is also commonly had, but is different from professional liability. General liability would be if you're surveying a piece of property and you step out into the road, oncoming car swerves to miss you, hits another car, causes a wreck. That has nothing to do with the quality of your surveying or your professional judgment, but your conduct caused an accident that you're liable for. And so general liability would step in and cover situations like that. So general liability is something that almost anybody or almost any business, whether if they're even licensed or not. For example, if you had a lawn care business, you don't really have to have a professional license to cut grass. I'm not making a lot of that, but you would want to have general liability for people slipping and falling on shrubbery clippings or from rock being thrown from a mower or something. So that's general liability. Professional liability insurance covers professional activities. In other words, activities that are unique to the profession. So this covers loss from errors and omissions of professional conduct. It can be just like a mistake made during a surgery that a doctor has professional liability insurance on. Now, in the medical field, they call it malpractice insurance, but surveyors can also be guilty of malpractice. The legal term is professional negligence. That's when you're liable and you want to pay. So professional liability insurance is not required in most states, including Georgia. In other words, you do not have to have it. You don't have to have anything unless you're operating an automobile and you have to have automobile insurance. Or if you have 3 or more employees and you have to have workers' compensation insurance. Everything else it's up to you. It's not advisable, but it's optional. So it's generally held as a good practice to have professional liability insurance to make sure that the client is covered, because if you made a mistake and you can't afford to fix it and your client suffers a big loss, everybody's a loser. I can also tell you that not having it can keep you from having some of the more lucrative projects out there, because often the larger, higher paying projects and clients require professional liability insurance in order to get their work. And if you do things right, it more than pays for the premium. License maintenance. Now you're going to get a surveying license after you pass all the tests. Make sure that you keep track of when those licenses expire and the requirements to keep them renewed, even if it's just one. Saying that you didn't get a reminder in the mail or that your email blocked the notification is not an excuse. You are responsible for knowing when your licenses expire and renewing them. I saw lots of people try to claim that they shouldn't have to renew them because they didn't get a reminder in the mail or they didn't realize they had to renew them. Don't make that ignorant mistake. Something that's also a little confusing is a firm, company, partnership, LLC, any entity that's offering surveying services in Georgia or most other states, not all, but most. The firm is required to get a certificate of authorization. Some call it a firm license. So it's kind of hard to explain why you need that. The purpose of it is to make sure that each business has at least one licensed individual at each office, and that you're not doing that inadequate supervision. So, for example, in Northeast Georgia in the 1970s, there was this one very prolific and profitable surveyor who had 4 offices. And he went to each office 1 day a week, and then he took a 3-day weekend. So he was in each office 1 day a week. Sometimes less if he got tripped up, got sick, or wanted to travel more. So at most, he was in that office 4 times a month. And the quality of work suffered, the quality of work varied from one office to the other. It was basically like he was running 4 different companies. So the certificate of authorization is going beyond just the individual who has to have an individual license to survey, for example, in Georgia or North Carolina or Alabama. And in order for the company that surveyor owns or works for to survey, the company needs a license. And the company, is required to have a licensed surveyor, but they're also looking to make sure that that surveyor is not qualifying more than one location. That is the main focus and purpose of a certificate of authorization. My time on the state board, I heard from people, I've got a business license from the city, I've got my surveyor's license, I've set up my company with the Secretary of State's office and the corporations division, I pay that every year. Why do I have to have a 4th license? I agree, that's a lot of government, I'm not necessarily defending it, but that is the purpose. But here, let's give you a legal aspect of it. Let's say that surveyor does everything wonderful, does a good survey, but they did not have a certificate of authorization. Let's say that good survey goes to court. It differs with the neighbors. The neighbors, they're in a lawsuit over a boundary. The surveyor who has the other 3 licenses and who did everything right, and just say he or she is correct in this lawsuit, their credibility is going to be destroyed, because they can say, well, you didn't comply with this state law to get a certificate of authorization. Why is that? There's no good answer there. You're going to be followed up with, how do you decide which laws you want to abide by and which ones you can just carelessly disregard, Mr. or Miss Surveyor? Impeaches the credibility of the witness. The other thing is, if the firm did not have a certificate of authorization, you could also make the legal argument that the plat was not legally prepared and have it disqualified as evidence, which means if you've got Party A versus Party B in court, Party A's plat gets thrown out, Party A is probably going to lose. And because then, even though the survey was right, if it got thrown out on technicality, basically, then Party B is going to win even if they had the mistake in the survey. Now they're correct by virtue of the court ruling. Well, Party A is going to come after that surveyor and make him pay, make him or her, pay the damages. So this is just another thing to where, professionals have to, be diligent, pay attention to detail, and just make sure that you're not overlooking anything or taking anything for granted. Don't be hesitant to question everything and make sure that you've got all of your bases covered. Another requirement that's kind of similar is continuing education. Now, the main purpose of this is for the surveyor to be up to date. I can tell you that, when I got my first degree in 1990, I got my first state license in 1996. Things have changed a whole lot since both of those dates. I'm still not 1,000% up to date on everything because I couldn't tell you how to operate a laser scanner or to fly a LiDAR head mounted drone. But I am up to date on what's going on, sufficient for my field of expertise and the work that I do and that my firm does. How did I do that? Continuing education. Now, that's not just 2 days in a seminar every year or every other year. That's continuing my professional education. I've gone back and taken additional courses. I've completed additional degrees. I've read manuals. I have watched training videos. I have been to training seminars. All of this is continuing education. Now, because some people do not do that, and it can be detrimental, most states, including Georgia, have implemented continuing education requirements where your continuing education efforts have to be documented. In Georgia and in most states, surveyors are supposed to keep a log, like a logbook, like a list of all continuing education. And depending on the state, We'll have to upload or input the info from our continuing education activities to demonstrate compliance. So here's another, sort of a contingent liability aspect is if you don't have your continuing education in place, because a lot of surveyors, maybe not a lot, but there are a significant amount of surveyors who will simply say, I have complied with continuing education requirements, when they have not. This is from my personal experience as a state board member. That opens the door for what else are you doing wrong? Sort of like the other example, how do you determine which laws you comply with and which ones you just carelessly disregard? Your credibility can be destroyed. If you had a board complaint filed against you and you were kind of, maybe had a little bit of a defense, maybe it was a little bit skimpy, but you hadn't got your continuing education, well, now you're probably going to get the boot thrown at you. It's kind of like being pulled over for going 7 miles over the speed limit. You're probably going to get a warning and turn loose unless your license is expired or maybe your insurance is out of date. Then you're going to get charged with all of it. So make sure you've got your continuing education up to date. There's also another very important aspect that doesn't get talked about a whole lot with continuing education. States that mandate continuing education are basically mandating you to be up to date on all the laws and the rules. So if the laws changed 2 years ago, 2 months ago, 10 years ago, and you're still going by the old, you don't have any excuse. I saw this with the various changes in the Plat Act over the last 8 or 10 years. Surveyors continued to do things like they were done in 1995. And they say, oh, I didn't know. Well, they're admitting that they're not up to date on their continuing education, but they don't have any excuse. In other words, you don't get, well, okay, you can do it by either standard. No, the law says you do this. You put a 3x3 box in the upper left corner now. That's the law. You got to do that. And you should know that at least within a 2-year cycle of continuing education and license renewals. Everybody should know and be up to date. As to continuing education, a common source of continuing education opportunities are the conferences and seminars put on by professional societies. Professional societies are generally very good to be participating in. Sometimes it's hard to see the benefit. It's easy to say that's a waste of time. And I can tell you that probably less than half of active surveyors are active in a professional society, but most are members. If you're a member, you're supporting a political action committee and a lobbying effort for the profession in your state and at the national level, if it's a national professional society. When laws are being introduced that would be harmful to the surveyors, the professional societies and their lobbyists combat that. When there are changes that need to be made to help surveyors, the professional societies and their lobbyists get involved in the legislature and push those. So it's not just a worthy cause, it's helpful for our professional survival. So it's really important, in my opinion, to be a member, whether if you go to the chapter meetings or not, whether if you go to the annual seminars or conferences or not, but I would suggest that you do at least on a, every other year type basis or something. So again, ignorance is no excuse. Professional societies do a good job of keeping changes to the laws up front and in place so that you know about them. In Georgia, we have the Surveying and Mapping Society of Georgia, otherwise known as the acronym SAMSOG. The national level used to be the American Congress of Surveying and Mapping, ACSM, which used to be partnered with ALTA. They've since kind of merged with a newer society that's now the only one, which is NSPS, which is the National Society of Professional Surveyors. So they get involved at the federal level. So in closing, be a professional. Don't just be somebody with a license. Don't just be somebody that knows what they're doing. Take your role in society carefully. George Washington, Andrew Jackson, well, excuse me, Thomas Jefferson, Abe Lincoln, they were professionals. They were respected in the society. They did more than just what they needed to do to make their own self better. Understand there is a lot to it. It's not just getting a stamp and getting a job. You have a lot of other responsibilities. You have professional continuing education requirements. You have these various rules and laws. You have a code of conduct. You have conflicts of interest to be managing. Pay attention to detail. A lot of these things, you might let them jump out at you. They might sneak up on you, but they're all there. So just pay attention to the detail in a lot of these things and be diligent. So, don't just take things for granted. Don't just assume that it's okay because this is how they did it at your old company or this is how everybody else does it. Be diligent. Read it for yourself. And when things come up, when you're asked questions or when you have to make decisions, respond very carefully. Think about your answers. Think about what you're basing it on. Make sure that any statement you make is based on facts and observations that you have professional background in. Respond very carefully. Hopefully this has been a help to you. If you have any questions, please reach out to me. Thank you.